We have prepared a written judgment in this matter. My brother and I are going to be reading out a truncated version of that judgment. The full judgment will be handed down to the parties as soon as we are done with that exercise. It is a unanimous judgment of this court. The ANC applies on an urgent basis for a judicial review and a setting aside of the decision made on 7 September 2023 by the Deputy Chief Electoral Officer, the DCO, of the Electoral Commission, duly delegated by its Chief Electoral Officer, the CEO, to register Umkhonto weSizwe Political Party, MK, as a political party. We conveniently refer to this decision as the impugned decision. The ANC and MK are political parties registered as such in terms of Section 15, subsection 1 of the Electoral Commission Act 51 of 1996. The Electoral Commission is established in terms of the Constitution. Although the ANC does not seek an order against the MK, it appropriately cited MK in these proceedings. The order the ANC seeks has a substantial bearing on MK's interests, specifically the right of its founders and members to make political choices in terms of Section 19 of the Constitution of the Republic of South Africa. This right includes the right to form a political party. Registering a political party with the Electoral Commission is an important process for achieving this right. Once registered, a political party is an important medium through which the other rights protected in Section 19 are realized. These rights include the right to participate in the activities of the political party and to campaign for a political party or cause. Political party membership is also a platform through which citizens stand for and, if elected, hold public office. It is therefore hardly surprising that although the ANC seeks no order against MK, MK is vigorously opposing these proceedings. The Electoral Commission also opposes the application. The ANC seeks to invoke the court's review jurisdiction in terms of Section 20, subsection 1 of the Electoral Commission Act. This provision, read with Rule 6 of the Electoral Court Rules, requires that it brings the application within 3 days of the impugned decision being made. It acknowledges that it failed to bring the application within the prescribed time. It is for that reason that it seeks condemnation for its delay in bringing the application. The ANC seeks that the impugned decision be reviewed under the principle of legality. In essence, the ANC's case is that the DCEO acted unlawfully and outside the bounds of the law in that he registered the MK, in that when he registered the MK, there was no application before him for such registration. It also alleges that the 2 notices published by MK in the Government Gazette, as required in terms of Section 15, subsection 4 big A, which we refer to in this judgment as Section 15, subsection 4 big A notices, were defective. The ANC is not persisting with this ground of review. The respondents have raised several points in limine. They both oppose the urgency and condonation relief with which the ANC seeks. They also contend that this court lacks jurisdiction over the matter. Both respondents oppose the application on the merits. Essentially, they contend that the application falls to be dismissed because when he made the impugned decision, there was a proper application for registration of MK as a political party before the DCO, and the impugned decision was lawfully made in terms of Section 15, subsection 1. On 1st June 2023, MK lodged with the DCEO its application for registration as a political party. On 9 June 2023, MK caused a Section 15, subsection 4 big A notice of its application to register as a political party to be published in the Government Gazette. It published a corrected Section 15, subsection 4 big A notice on 30 June 2023 after the Electoral Commission alerted it to defects in the 1st June 2023 notice. No objections were made in response to these notices. In a letter dated 4 August 2023, transmitted to MK by email on 8 August 2023, the DCEO advised MK that he rejected its application for registration as a political party because the signature of its purported supporters on the deed of foundation showed patterns of discrepancies which indicate that the signatures were made by a person other than a voter. The DCEO further advised MK that it was not precluded from submitting a fresh application that complies with all the applicable requirements. MK supplemented its application by remedying the defects identified by the DCO and resubmitted it on 30th August 2023. The DCO reconsidered the application, found that it met all the applicable statutory and regulatory requirements, and registered MK as a political party on 7 September 2023. On the 11th of September 2023, the ANC learned that MK was registered as a political party when it saw on social media a letter by the Electoral Commission to that effect. On 20th September 2023, the ANC lodged an appeal with the Electoral Commission against the DCO's decision to register MK as a political party on the basis that MK's registered name and its distinguishing mark or symbol resemble the name and the distinguishing mark or symbol of the ANC to such an extent that it may deceive or confuse voters as envisaged by Section 16, subsection 1B of the Electoral Act. On 24th November 2023, the Electoral Commission dismissed the ANC's appeal on the basis that it had failed to object, as required by Section 15, subsection 4B of the Electoral Act, to the registration of MK within 14 days from publication of MK's notice in terms of Section 15, subsection 4BA notice. The issues that arise for determination are primarily issues of law. They are as follows. A, whether the ANC's delay in bringing the application should be condoned. B, whether this court has jurisdiction over the relief the ANC seeks. C, whether there was a proper application for registration of MK when the impugned decision was made, and for that reason, when he made the impugned decision, the DCO acted beyond the scope of his powers as set out in Section 15, subsection A. I will now deal with the points in limine. Urgency and condonation. The ANC acknowledges that it brought the application outside the prescribed three-day period. It has put up an application for the delay. It contends that if it is not afforded an urgent audience, it will be denied substantial redress in due course. Since it did not bring the application within 3 days of the impugned decision being made, in terms of Rule 10, the ANC is barred to bring the application unless, on good cause shown, this court directs otherwise. The party seeking condonation must give a full explanation for the delay. This is one of the factors to be considered when determining whether a condonation should be granted. The explanation must cover the entirety of the delay. The court also considers whether granting condonation would serve the interests of justice. The impugned decision was made on 7 September 2023. The ANC only brought this application on 9 January 2024. Its explanation for bringing the application outside the prescribed period is that it was not aware of the DCO's letter of 4th August 2023, which grounds this review because there is no statutory obligation on the DCEO to publish his decision not to register a political party. It only became aware of this letter in January 2024. The ANC's explanation is irrational because it doesn't come close to justifying its delay in bringing the application late. It is not impugning the decision of the DCEO made on 4th August 2023. It is therefore irrelevant that it only became aware of this letter in January 2024. The ANC became aware of the impugned decision on 11 September 2023. At that stage, it took a decision to appeal the decision with the Electoral Commission in terms of Section 16, subsection 2. It lodged the appeal on 20th September 2023. The Electoral Commission considered the ANC's appeal and dismissed it on 24th November 2023. The ANC alleges that it discussed the 24th November 2023 decision internally. A decision was made to pursue legal proceedings. It was only able to instruct its attorneys on 26th December 2023 to institute this application. Between the 26th of December and the 31st of December 2023, several consultations between ANC and its officials and I'll read that again. Several consultations between ANC officials and its legal representatives were held. After these consultations, its legal representatives started drafting papers. It blames the delay in bringing the application on the timing of the Electoral Commission's 24th November 2023 decision, as well as the fact that its members and legal team were closing offices for the December holidays. To lessen its inordinate delay in bringing this application, it contends that the clock started ticking on 24th November 2023. Yet it painstakingly explained that it is not impugning this decision in these proceedings. What renders the ANC's explanation even more irrational is that it did appeal the impugned decision to the Electoral Commission within the prescribed period. The period is prescribed by Section 16, subsection 2B. This resulted in the Electoral Commission's 24 November 2023 decision. It does not impugn this decision in these proceedings. It impugns the decision the DCEO took on 7 September 2023, which it became aware of on 11 September 2023. Therefore, the fact that the ANC initially decided to appeal the 7 September decision to the Electoral Commission does not justify the delay in bringing the present application. The timing of the 24th November 2023 decision also does not justify the delay in bringing this application. Notwithstanding that this decision, taken on the 24th November 2023, does not justify the delay, The ANC also fails to fully explain why it took more than 1 month that decision was taken to discuss and decide its next course of action. If its offices were closing for the festive season, the statutory requirement for urgency in this application ought to have urged it to act with the requisite urgency. It fails to state on what date its offices closed in December 2023. Ironically, it instructed its attorneys in the peak of the December holiday period on 26 December 2023. It fails to explain why it could not do so earlier. It offers no explanation why it took a further 2 weeks after it instructed its attorneys for the application to be instituted. In any event, these omissions are of no moment because the ANC's appeal to the Electoral Commission against the 7 September decision does not justify the delay. It ought to have instituted the present application within 3 days of becoming aware of the impugned decision. At that point, the festive season was more than 3 months away. The ANC's contention that it only became aware of the DCO 4th August 2023 letter to MK in January 2024 also does not justify the delay. It concedes that it should have been more diligent in accessing MK's registration file at the Electoral Commission. Notably, the ANC underplays the primary cause of its predicament. It blames the fact that it was not informed of the DCO's letter of 4th August 2023 because there's no statutory obligation on the DCO to publish the rejection of an application for political party registration. The statutory obligation to inform a third party of a decision not to register a political party is implicit in Section 16, subsection 2 of the Electoral Act. This provision regulates appeals against the DCO's decision to register or not to register a political party. Initially, this section gave any person the right to appeal the DCO's decision to register or not to register a political party. It was amended in 2021 to limit the right to appeal against the decision not to register a political party to the applicant for registration and the decision to register a political party to a third party who objected to the application for registration during the 14-day objection period, which runs from the date of publication of the Section 15, subsection 4BA notice in the Government Gazette. This statutory amendment is important as it enhances the Electoral Commission's internal dispute resolution mechanism provided for in the Electoral Commission Act. It affords third parties an opportunity to express their interest in an application for registration of a political party by having their objection to an application determined by the Electoral Commission as early as possible in the registration process. As evident from the present facts, electoral processes are not only manifestly urgent, as already stated, they also facilitate the realization of political rights enshrined in the Constitution. As the Electoral Commission explained, it has a statutory duty to promote the realization of these rights. Hence, its approach to applications for registration is to assist applicants to register and not to make it difficult for them to register. If a party who is grieved by the registration of a political party only raises a dispute after the decision to register a political party is made, it could have a prejudicial effect on the realization of the political right of the party applying for registration, particularly in a case such as this one, where the application for registration was made 11 months before national and provincial elections scheduled for 29 May 2024. I'll read that sentence again. If a party who is grieved by the registration of a political party only raises a dispute after the decision to register a political party is made, it could have a prejudicial effect on the realization of the political rights of the party applying for registration, particularly in a case such as this one, where the application for registration was made 11 months before a political party. The impugned decision has serious implications for South Africa's democracy, as political parties are an important vehicle for the exercise of political rights enshrined in Section 19 of the Constitution. The ANC contends that if its application is not heard, it will be denied substantial redress in due course because it is impugning MK's registration on the basis that it is unlawful. If the application is not heard, an unlawfully registered political party will, to the prejudice of voters, participate in the national and provincial elections scheduled for 29 May 2024, thus denying it substantive redress in due course. We find that there's no merit in this contention. For the reasons I've already stated, the ANC is not only barred from bringing this application, but also non-suited by operation of law. It is therefore not entitled to substantive redress in due course. Therefore, in terms of Rule 6, read with Rule 10, it does not meet the requirements for condonation. The ANC is facing an even greater hurdle. It impugns the 7 September 2023 decision in the wrong forum. The impugned decision was lawfully made. All these factors do not support the exercise of this court's discretion to overlook the delay in the interests of justice. We set out reasons for these findings below. I now deal with the jurisdiction point in limine. The ANC seeks to invoke this court's review jurisdiction. The respondents contend that this court lacks jurisdiction to review the impugned decision, as it is not a decision of the Electoral Commission. When interpreted with reference to the language used, the context and purpose of the Electoral Commission Act, the interpretation in Section 20, subsection 1, which the ANC is contending for, is unsustainable, as it will undermine the dispute resolution scheme created in the Electoral Act. As already held, when it failed to object to MK's application for registration, the ANC became non-suited. The Electoral Commission Act does not make provision for an aggrieved third party to impugn a political party registration after the period provided for in Section 15, subsection 4 big A notice has expired, or by way of these proceedings, as the ANC seeks to do. Section 16(2)(b) only affords parties who objected the right to impugn the DCEO's decision to register a political party. The ANC could not successfully use the internal dispute resolution mechanisms provided for in the Electoral Commission Act when it appealed the impugned decision to the Electoral Commission. The appeal was dismissed because the ANC is non-suited in terms of Section 16(2)(b) from impugning that decision. This application is also unsustainable because the ANC can only impugn the Electoral Commission's 24th November 2024 decision invoking the Electoral Court's jurisdiction in terms of Section 20, subsection 1. The ANC has preempted that decision. Notably, when it appealed the impugned decision to the Electoral Commission, it did not raise the ground of review it raises in these proceedings. The ANC blames the DCO for non-suiting it when he considered MK's supplemented application and not a fresh one, as stated in his 4th August 2023 letter. It further contends that had the DCO insisted on a new application for registration being filed by MK, the latter would have had to publish a new section 15, subsection 4 big A notice, thus affording it an opportunity to become an interested party by objecting to MK's application for registration. Hence, it contends that the DCO's decision falls to be reviewed and set aside as it was unlawfully made. The predicament that the ANC finds itself in does not justify a wide interpretation to Section 20, subsection 1. Such an interpretation would undermine the statutory dispute resolution mechanism provided for in the Electoral Act. It also does not promote the realization of the rights in Section 19 of the Constitution. We therefore find that the Electoral Court lacks jurisdiction to review the DCO's 7 September 2023 decision. It only has jurisdiction to review the Electoral Commission's 24th November 2023 decision, which the ANC has effectively preempted, as it is not reviewing it. For these reasons, the respondent's jurisdiction, point in limine, stands to succeed. I will now hand over to my brother to deal with the merits.
Yes. Under the heading, the merits, the judgment provides as follows, and this is just a truncated version of what the judgment says. The only issue to be considered by this court is whether the DCEO acted lawfully and in compliance with the peremptory procedural requirements for the registration of a political party when he registered MK. Crystallized further, the question to be decided by this court is whether the DCEO, in having had regard to a so-called, quote, supplemented, end quote, application by MK, when he registered MK as a political party, acted within the four corners of Chapter 4 and Section 15 and 16 of the Electoral Commission Act, read with its regulations. Contrary to the ANC's contention, not much turns on the interpretation of the DCEO's letter of 4 August 2023. The ANC's case is that the provisions of Section 15(1) were not complied with by the DCEO when he made the impugned decision. This, the ANC contends, was due to the fact that the application which had been filed by MK and in respect of which there had been publication in terms of Section 15(4)(a) had been vitiated and in effect rendered pro non scripto by the DCEO's rejection letter of 4 August 2023, in which he advised MK as follows, and I quote, "Please take note that the application for the registration of the above-mentioned party has been rejected because the signatures of supporters on the deed of foundation showed patterns of discrepancies which indicate that the signatures were made by a person or persons other than the voter," end quote. The ANC argues that MK failed to submit a, quote, fresh, end quote, application. It also failed to publish a fresh Section 15(4)(a) notice in the Government Gazette, informing the public that it seeks registration. Instead, it supplemented its initial rejected application, even though there is no provision in the Electoral Commission Act for supplementation of an application that has been decided upon and rejected. Pursuant to such supplementation, the CEO unlawfully registered MK on 7 September 2023. The law applicable to the registration of political parties, in particular Section 15(1) of the Electoral Commission Act, and its interpretation, so the argument on behalf of the ANC is concluded, does not permit an application for registration to be supplemented. Its interpretation of the said section, according to the ANC, is supported by the 4 August 2023 letter, which clearly and unambiguously states that MK's application was rejected and that it is not, quote, debarred, end quote, from submitting a, quote, fresh application complying with all the requirements, end quote. Whether these submissions on behalf of the ANC are sustainable depends on a proper interpretation of Section 15, read with the regulations and Annexure 1 thereto. It is so, as was held by the Constitutional Court in Fetchua Life Assurance Limited and others, that the legislature and the executive in every sphere are constrained by the principle that they may exercise no power and perform no function beyond that conferred upon them by law. The simple point being that in terms of the principle of legality, the CEO could not register a political party in a way and in terms of a procedure that he is not empowered to do by the Electoral Commission Act. We find that the requirements for the registration of MK in terms of Section 15 of the Electoral Commission Act, read with the regulations and the annexures thereto, properly interpreted, were met. The important point about Section 15.1 is that in peremptory terms it envisaged that the CEO, quote, shall, end quote, register an applicant as a political party upon application, quote, upon application by that party in the, quote, prescribed manner and form, end quote. We interpret this clause, quote, upon application, end quote, to require the CEO to have before him the application, quote, in the prescribed manner and form, end quote, when he registered the applicant as a political party. It matters not on the construction of the section that the construction of the section, the regulation, and Annexure 1 thereto, how the application came before him, or whether it came before him in one go or in phases, or, for that matter, in the proverbial, quote, drips and drabs, end quote. Contrary to the ANC submissions, the absence of a reference to Section 15.1 to, quote, supplementing, end quote, of the application does not detract from the fact that on a plain reading of the provision, the words, the grammar, and the syntax of the section lend itself to an interpretation that as long as the application in the prescribed manner and form is before the CEO, he should register the political party. The ANC's contention that because the section makes no reference to supplementation, an application cannot be supplemented holds no water. It is an artificial approach. It implies that contrary to the substantive approach to the consideration for an application for registration, as implied from the reasons for which the CEO may decline to register a political party, which are set out in Section 16.1, the CEO should refuse to register a political party for elementary administrative details which the Act and the regulations did not deem necessary to prescribe. Nowhere in Section 15 of the regulation or the regulations is the manner in which the application is to be submitted prescribed. Importantly, the section does not require an applicant to comply fully at the first go. As regards context, there was no need for an applicant after an application for registration is rejected by the Electoral Commission to commence the whole process afresh. 14 days had passed since the corrected Section 15.4a notice was published on 30 June 2023, and the ANC had not registered an objection. Therefore, the DCEO was not prohibited from registering MK in terms of Section 61. Moreover, the Electoral Commission has demonstrated that there were other political parties which also supplemented their applications after initial rejections, whereafter their applications for registrations were approved. This translates into a contextual interpretation that favors the respondent's case. As for purpose, at the heart of Section 15 are the political rights enshrined in Section 19 of the Constitution. With that purpose in mind, Section 15 is aimed at ensuring that every citizen can form and register a political party. That therefore means that the said section should be interpreted in a way which facilitates the formation and registration of a political party as against hamstringing it. That purpose is attained by an interpretation contended for by the respondents in casu. For all of these reasons, it is iterated that the DCEO in registering MK complied with the requirements of Section 15 of the Electoral Commission Act, read with Section 16.1, the regulations and Annexure 1 thereto. We therefore find that there is nothing unlawful about the registration of MK by the DCEO on 7 September 2023. As regards costs, in line with the principle in Bywatch, costs are customarily not awarded in this court. We have not been persuaded to depart from this custom.
The order reads as follows. In the result, the following order is made. The application is dismissed with no order as to cost. As to costs. We hand down judgment. Gladys? Gladys?
In the media summary.